to the Battle of Homestead Foundation's Monday Markers program. This is it will be aired on November the 16th. It's the 22nd program, and it concerns the J&L decision of the U.S. Supreme Court, J&L versus NLRB, the New Deal and labor rights. In early July 1936, 44 years after the Great Homestead Steel Strike of 1892, a rally was held in Homestead by the Steelworkers Organizing Committee to adopt a Declaration of Independence. Independence from the Lords of Steel who tried to rule us as did the Royalists against whom our forefathers rebelled. The Declaration was printed on the front page of the very first issue of Steel Labor, the steelworkers' paper to this day. In 1935, the National Labor Relations Act, or Wagner Act, was passed by Congress to replace the National Industrial Recovery Act that had been struck down as unconstitutional by the all-Republican named Supreme Court. In the November 1936 elections, however, Franklin D. Roosevelt won a massive victory at the same time that labor-supported local Democratic candidates swept the industrial valleys of western Pennsylvania. So while pro-labor candidates now were judges and mayors and council members and police chiefs, there was great concern that legal protections for workplace concerted activity and collective bargaining would fall victim to the conservative court. FDR's electoral victory inspired workers to engage and become extremely active in widespread sit-down strikes and factory occupations, the most famous being the Flint, Michigan General Motors sit-in, an occupation of the plant. The combination of labor's direct action with important political advances at all levels of government won a union contract in auto. Most observers then anticipated that a fierce struggle would begin in steel. However, U.S. Steel's head, Myron Taylor, confronted by the changing political realities and having received rising orders for armor plate and other steel products from European countries alarmed by German militarism, in secret negotiations with the CIO's John L. Lewis, shocked the corporate world by recognizing the Steelworkers Organizing Committee as the bargaining agent for workers at U.S. Steel. While U.S. Steel was the largest steel company, the next five large producers, the so-called little steel companies, vowed to resist. Jones and Laughlin, the nation's third largest steel company with major facilities in Aliquippa and Pittsburgh, had fired hundreds of men for union activity. It was the lead company in a test case for the Wagner Act, where, in response to a union election petition, the company refused to negotiate. An ethnically diverse group of 10 fired workers filed an unfair labor practice charge demanding reinstatement and a government-supervised union election. J&L then challenged the constitutionality of the National Labor Relations Act and took it to the Supreme Court. President Roosevelt, faced with interstate labor turmoil and fierce corporate resistance, strategically floated the idea, the possibility of adding additional members to the U.S. Supreme Court to break the court's blockade over New Deal federal action that had been advanced to confront the deep economic depression that had the country in its thrall. The court, confronted with the Wagner Act, one of the judges who had ruled against the National Industrial Act switched, and the dramatic breakthrough is called the switch in time that saved 9, and the Wagner Act was upheld. In the ruling by Chief Justice Charles Evans Hughes, former governor of New York, who had hired Crystal Eastman to write his workers' compensation law, some very important principles were established. The first was the assertion that because the power of an individual worker was so weak in the face of massive modern corporations, the recognition of a union was a necessary condition for any kind of fair bargaining on an equal level with employers. Second, the court recognized an important limitation of the corporation's employment at will, the foundation of American labor relations. And the court said that while the employer has the right to select its own employees, it cannot exercise this power to intimidate or coerce workers when they organize and seek representation to have their voice heard on the job through a union. And thirdly, because there was or is no explicit right to workplace organization in the U.S. Constitution, the federal right to speak to these issues rested on the Commerce Clause that allowed government regulation of interstate commerce, the Commerce Clause of the Constitution. The American legal system's hostility to labor organization, going back to the 1814 Pittsburgh cordwainers conspiracy trial, was rooted in English common law's characterization of unions as a conspiracy to act in restraint of trade, thereby curtailing the rights of private property. The crime was in the togetherness, the joining together, the conspiracy, the breathing together. An individual worker who was not a slave could quit his job. But if 2 or more workers got together as a group and left the workplace, that was concerted activity and a crime against property. The 1937 Supreme Court decision, the J&L decision, reversed that logic. It held that the suppression of workers' voice on the job was the cause of strikes and plant occupations that disrupted commerce. So concerted activity by workers for rights on the job was the means by which interstate commerce was interrupted and put the systematic violation of workers' human and labor rights by corporations under the purview of the Congress and the courts. When news of the Supreme Court decision hit Aliquippa, the populace rose up in exuberant celebrations with mass parade and outburst of parties. And Pete Sikoric, a union activist, summed up the feeling. When I hear Wagner Act went constitutional, I happy like anything. I say, good. Now Aliquippa become part of the United States. A 2-day strike followed the ruling, and there was a mounting fear of violence when suddenly the governor of Pennsylvania, George Earle, showed up at the gates of the plant at the famous tunnel and ordered the company to remove all weapons, and that afternoon, a union contract was settled that same day and ratified by over 60% of the workforce.